Good afternoon, folks. Welcome. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. We have started doing one at LinkedIn one Thursday and one here at our personal conference. So you can join us in either one. Now, as you logged in, you would have heard that this call is being recorded. So if you want to keep your identity confidential, by all means do so. I also want to note for the record that this is not an attorney-client relationship-making call. This is just providing you generic information as we see presented in various questions. Okay, so all the disclaimers that you heard while logging into apply. That said, let's begin. First, I don't have any frequently asked questions today. Normally I mark them first. All I have is the usual questions. So let me just double check you guys can hear me. Sometimes I forget to check that. 1 second.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you hear me? Hello?
Yes, we can hear you.
Okay, excellent. Thank you.
Yes, we can hear you.
The
Excellent.
conference is now in presentation mode.
So the first question I had today was the emergency visa request denied, etc., etc. But then the good news is that this visa was granted. So there was an emergency visa request for some very pressing reasons. I was surprised that they denied it. But then I got an update saying that this has been granted. So we are good with this question. We don't need to address this question. Let me move on to the next question. So this is a difficult situation. Let's see, we did this already. Vijendra's situation is quite difficult. What happened was he had an initial OPT, applied for STEM OPT. Initial OPT will expire on May 1st, 2023. On March 31st, I got a denial letter. On April 4th, my initial OPT was marked completed. I'm already out of status for now. Here are my options. File an appeal. Well, there is no appeal. You mean motion to reconsider. I think this is something you need to know, which you may not know, that if there is an error made by the government, okay, you can actually request an expedited resolution of your case. So if you file a motion to reopen/reconsider and you request expedited response on that because it is a government error, then chances are they will expedite it and within a few days they might approve the case. Okay, there is a process for it. You can call the USCIS customer center and it's going to take you all day to get through, but once you get through, you can let them know that I want to file a case and I want to expedite based upon government error. Okay, you can actually just Google it or Bing it or whatever search engine you use. USCIS expedite criteria. USCIS expedite criteria. I think that may be the first thing you should do. Okay, simultaneously open a case with the USCIS Ombudsman office. Okay, so that the Ombudsman, OM as in Mary, BU, B as in boy, U, D as in doctor, Budsman, S as in Sam, man as in man and woman. Okay, Ombudsman. USCIS Ombudsman can help you expedite the cases also. So if you just Google USCIS Ombudsman case request or just case, you should be able to come to the page where you can make a request to the USCIS Ombudsman and they will be able to expedite the case. They are a little slower than just calling the USCIS and asking for an expedite of your case based upon government error. So I think that should work. And it might even be that they can reopen your case without you having to go through a motion to reopen. If you are here, let me talk to you. Vijendra, are you here? Press *5 if you are. Press *5 on your phone if you are here. Okay, so you are not here. But just follow what I just told you, follow the instructions, okay? Let's go on to the next question. So E15 immigration status for children of EB1C. Well, I think this is about CSPA. Let me see. Children of I-140 EB1C approved, came to US on B1, applied for I-140 EB1C, got my EAD and advanced parole in July. My I-140 EB1C is pending. Okay. What are the forms needed and timeline for E15 immigration status for kids? Well, that's a very difficult question to answer because there are a couple of options that your lawyer should discuss with you. But normally what happens is there are two options. Either everybody is here and you file for adjustment of status together, or consular processing for all or some of you. So since you are here, it's basically a split case. You are doing your adjustment of status here while the children would be doing consular processing from India. The form is I-824, but you should get a lawyer involved. Don't try to mess with it yourself. There are too many ways this can go sideways. Will my elder son be eligible? Well, that is a CSPA calculation, Child Status Protection Act. This is what I would recommend. It's not difficult to do, but it takes sitting down and working out the days and years. So just Google USCIS CSPA, Child Status Protection Act calculator. Okay. So you'll be able to come to USCIS policy manual where it shows you how to do the CSPA calculations for the child of an employment-based applicant. Okay, the child of an employment-based applicant. Just to give you the broad thumbnail on that, basically, the only time you can deduct from the child's age is the time during which the I-140 was pending. Okay, so that will be deducted. So if the child is still, by that calculation, after the deduction, you come to what is called CSPA age. So if the CSPA age is under 21 on the date you file for their I-824 or adjustment of status if they are in the United States, then they'll be protected. Okay. *5 if there's a follow-up question on this. *5. Okay. This question comes from area code 832, which is Texas. Okay. Let's see, Texas. Yeah, Texas, go ahead, please. Texas.
Sir, my elder son is presently in India. So still the same calculation will be applicable, right?
Yeah, same calculation. Just go to that page. It's not difficult to understand. You just have to do the numbers. Okay.
Sure, sir. And I came in on B1, so because my I-140 is not approved, I'm not working currently, but when the processing, these documents are submitted, I need to submit proof of my income based on which they will be allowed. So can I start working now?
Ma'am, you need to get a lawyer because I don't know who advised you to file an adjustment of status when you are I-1 and B1. To my mind, that's a very bad move. Okay. Government can come back and say you lied to us when you entered on a business visa and applied for adjustment of status. So you really should be talking to your lawyers. Make sure that these decisions are properly made. As far as the ability to support is concerned, the letter from your employer offering employment would be good. By the way, when you go through the same package, this is an important point to remember. When everybody is filing through the same adjustment / following to join through consular processing, normally you should not have to submit any affidavit of support. Why? Because affidavit of support, I-864, can only be submitted by somebody who's already a green card holder or US citizen. So when you have applied for it, you're not a green card holder yet. You see my point? So you should not have to submit any income documents. Okay? But I strongly encourage you to please get together with a lawyer. I'm concerned that from what you have told me, I'm concerned that this paperwork is properly filed, timely filed. So just make sure you talk to your lawyers, okay?
Sure, sir. I also got my medical examination request and I submitted. They took it on account on Monday. So,
Okay.
yeah, I hope
Yeah.
it is going in the right direction.
Yeah. Very
Okay,
good.
appreciate
Good luck.
it. Thank you, sir.
You're
Appreciate
welcome.
it.
Bye. Okay, let's go on to the next question from Vineet Savant. Impact of job changes on approved I-140 and PERM. This is a very long history, guys. Try to make your questions a little shorter. So I'm not sure what's going on here. I'm on H1B. Company filed PERM in September. Couple of questions. The division I work for is closing. My plan is once I-140 is approved, my current role, I will move within the company and company will need to file new PERM. Okay, so basically, guys, just make a note of this. This is something important to remember for all of you. So when we file a PERM application and we know the job is consulting type of job or it's a job that is capable of being moved around, we never file from a branch or a sub office. We always file from the headquarter. So let's say the corporate headquarter is in Washington, D.C. You work in California branch and you could be moved to another branch, let's say to Minnesota or Illinois. So the smart thing would then be to file from Washington, D.C. when the job is transferable. Why? Because it is the proper thing to do. The U.S. Department of Labor about 30, 40 years ago said in an economy which is service-based and people move around, we will consider the corporate headquarters to be the job site. So that way, no matter how many times you move, you never have to file PERM again. And you never have to work from Washington, D.C. because the job is deemed to be located, even though it is not so. Okay? It is deemed to be located in Washington, D.C. because it's a transferable job and D.C. is the headquarter. Actually, the formulation is you can file from the corporate headquarter or the principal place of business, either one. These can be two different locations. Okay? So, yeah, if it was not filed like that, then you would have to start all over again. In this case, my initial approved I-140 will still be active even though company starts new PERM. Yes. So the rule is, first of all, the moment the I-140 is approved, that priority date becomes yours to keep even if the I-140 is withdrawn. Okay. The only exception to this rule is if the I-140 is revoked for fraud or misrepresentation or an obvious error by the USCIS. Okay. So the moment the I-140 is approved, the priority date is yours. Now, number two, in addition, if the I-140 stays approved for 180 days, stays approved, you don't have to be employed with that guy. You don't have to be there in that office. As long as it stays approved for 180 days, you also have the right to keep extending your H-1B beyond 6 years with any employer, even if the I-140 is revoked. So these are two different rights. One, you get right away when the I-140 is approved, priority date. Second one, you get after 180 days, as long as the I-140 stays unrevoked. Whether you apply for a different job, same job, doesn't matter. That same job provision, same or similar job is called AC-21 portability. That's different. This is a different rule. Okay. So then I'm aware that post I-140 employer has the right to revoke within 6 months. Employer has the right to revoke at any time, before 6 months, after 6 months. But that the after 6 months, 180 days actually doesn't affect you. So, and as I know my division is closing, so I move within the company after my I-140 approval. Now, post 6 months, can I leave this organization with my approved I-140 for my previous role? I have no idea what you're asking me. Star 5 if you're here, press star 5. This question is not clear at all, so you need to clarify this for me. This is a call from Massachusetts. No, Massachusetts? M-A. I always mess this up. Are you calling from Massachusetts, sir?
Rajiv, sir.
Where are you calling from?
Yes, Rajiv. I'm calling
Okay.
from Boston.
All right. So tell me, what are you asking me in this question number 2? I have no idea what this means.
So basically, I'm expecting my I-140 to get approved in August in case if I don't get audited. My current role is of project manager. After my I-140 gets approved and I move within the same organization, and then let's say in next Feb or March, I move outside my current organization. I think you answered that question while we were discussing the first part.
Yes.
I can just carry on my I-140.
Exactly.
That was the question, actually.
Exactly. Because the priority date is yours right away. That's never going to go away. And then after 180 days of the I-140 staying unrevoked, you have the right to extend your H-1B with any employer beyond 6 years. That doesn't mean you don't have to start the green card all over again. You do. But those two rights are protected. That's really a big deal. Okay.
Understood. Thank you.
Okay. So the third part was, does every organization will need to apply for PERM? Yes. PERM plus additional cost, half the organization do not want to opt for international talent. Can I work for that organization? In case any company is willing to start my H-1B but not ready to start my PERM, yeah, you can work. See, the only harm is if you have not gotten another green card approved, and if your priority date becomes current and stays current, government will not give you H-1B extensions without a very good reason. But that's so far in the future, you don't really need to worry about it. So in order for you to weather the storm, which is this bunch of layoffs until the market stabilizes, if you get a job on an H-1B and they don't want to start their PERM, take that job. Why? Because your priority date is already safe. And typically, what happens for what I have seen, again, I don't mean to be implying somehow that Indians are the best worker in the world. We are all a mixed bunch, just like everybody else. But proportionally, our guys, our boys and girls, they do such a good job that most employers want to work with them. Okay. So once you start working there, in a few months, they might change their mind. Right? That's what I would recommend. Okay. So then you said number 4, in case I lose my job post I-140 approval and I don't get a new job within 60 days, I'm aware that I can still apply for jobs while being outside USA. Yes. In this case, would my last approved I-140 be still active? Absolutely. Actually, you know what I'm going to do? I think I'm going to mark this as a frequently asked questions, Vineet, because there are things here that are actually relevant for everyone. So give me 1 second while I mark your question as a frequently asked question. Because this is definitely, in today's market, it's very important. So even if you're outside the United States, your I-140 approval, your right to extend, your H-1B, your priority date, none of that is going away. Okay? So you don't have to worry about that. What the heck? Why can't I see the... Okay, I'll mark it later. I'll just remember to mark it. Okay. Anything else I can help you with? I think those were the only questions you had.
Just to continue with the same 4th question. Once I'm outside United States, I believe in case if I get a job, do I need to get a stamping on the same new employer, or can I come with the older stamping in case that visa is still valid?
If the old stamping is still valid, you should be able to use it. Discuss it with your lawyers before you leave, because there are some technical issues. But in general, that should not be a problem.
Understood. Okay. Thank you so much.
No, wait. You have one more question. You said, just for awareness, what are the cases or situations when you lose your I-140 priority date? There are only 2 situations. One, if the I-140 is revoked by the USCIS for fraud or misrepresentation. Or 2, if USCIS finds they made an error in approving the case. That's very rare. It happens, but it's rare. Okay?
Okay.
Good luck, sir.
Thank you so much.
All right, bye-bye. Yeah, I have to mark this as a frequently asked question for sure. In about 10 minutes, I will lock out our conference. So that way I'll make sure that people who have already logged in and they still have questions, I'll answer their questions, even if they are new questions, no problem. Right now I'm just working on the posted questions. So the one of the questions is, I should mark this as a frequently asked question also. Recommendation letters for EB1A. For a strong case, a ballpark number on how many recommendation letters should one get? 5, 10? Quality, quantity? Definitely quality. Okay. So let me give you the general guidelines on what to do with your recommendation letters. Okay. First of all, people who know you by reputation and not personally are given more weight. People who know you personally are given less weight. Number two, it is not just the number of recommendation letters. It is the quality of the people who are giving recommendation letters. Your recommendation letter should be detailed, reasoned. Why are they recommending you? What is so special about you? What makes you the top 10%? How are the people writing the letters able to judge you? What are their own qualifications, their resumes? All this should be covered. Okay. Is there a validity of recommendation letters? If I apply 1 to 2 years later, I've had that happen. And the government one time actually asked me to give them more recent letters. And I said, my qualifications have only gotten better, not worse. So this can definitely become questionable if the letters are too old. So you might want to sit on that. But at the same time, if there's a choice between not getting a letter at all and getting an old letter, get whatever you can. Should they write on their official letterheads of the company, college, etc.? It's definitely better. But if they can't, I would add a line or two there that I'm not writing on my official letterhead because this is my opinion, not the opinion of my employer. Okay. So I think that would be helpful. Does anybody have any follow-up question on this? Actually, I forgot to ask you on the above question. I'll go back to the above question also. So from area code 917, I have two follow-up questions. 917 has called from New York. Okay. New York, go ahead. I can hear you.
Hi, Rajiv. Thank you. So have you an RFE on one particular recommendation letters? Because I ask this because what if down the line I go back to my recommender and he's unable to reach out and he's not helpful, he maybe not live. So what can I do with that?
You're pretty cheerful. Okay. All right. Okay. Yeah, I can understand that. Look, for whatever reason, if the recommender is not able to give a letter, just tell the truth. Tell the government, this recommender is no longer in this world. You'll have to get a letter from him in the other world. But if there's some other reason, for example, you can't locate them, they've moved on, you let them know. I tried calling them. I tried calling 3-4 numbers. This is the number I called, and they were not available. I couldn't find them. So I think it's perfectly okay. And if the government wants to discard that letter, so be it. Frankly, I don't think they should. What does a recommendation letter have to do with recency? It should be assumed that my qualifications from 2 years ago when the letter was written to now have improved. Obviously, I've not forgotten things. I would have remembered more things or learned more things. So that would be my argument, right?
Got it. And then if so is it better if I have 2 recommenders from the US, 2 from India, 2 from Canada, or all from India?
See,
is there like an advantage?
It is different for EB1A and EB1B. EB1A, I usually just get US recommenders. But EB1B, I want them from all over the world. Okay. Good luck.
But it's still okay to get recommendation letter.
Yeah, absolutely. For example, let's say you get a letter from, I don't know, the director of CERN. Okay. That's a big deal. Or somebody who's a Nobel Prize winner in Israel, that's a big deal. Okay.
Got it.
Good luck.
Sounds good. And then one last question on the, you said, like, official letterhead is not a mandatory requirement.
No.
So I think the only legitimacy here to prove is that just write a couple of lines at the bottom of the letter that, hey, for some reason, I'm unable to write on the official letterhead, but, this is the case, blah, blah, blah.
Well, actually, the government knows it. I have never explained why I'm not writing on official letterhead. And I've never received a kickback from the government saying, why does this gentleman not or this lady not write on their official letterhead? And the answer is because this is not their employer's opinion. And that would be highly inappropriate. Okay. So government has actually never questioned that.
Exactly.
So even if you don't write it, I think it's okay.
Awesome. Thank you so much.
You're welcome. Good luck. Okay, I think this one is from Florida, 813. Go ahead, please.
Hey, Rajiv. So I have a question on AC-21 portability.
No, wrong time to ask. No, wrong time to ask. I'll invite new questions later.
I'll wait till then.
Yeah, these are only follow-ups, so sit tight. I'll be with you. Okay, yeah, just please ask me only follow-up questions because we are isolating these answers. Now comes, next question. So this is a second frequently asked question. Then there is visitor visa overstay. So this is a very odd case, right? Because you just made a mistake. So each of the 3 times she overstayed, you thought it was 6 months, but it was 180 days. And even the officer made the same mistake. So in these cases, let's see, they stopped her from boarding. That doesn't make any sense. *5 if you are here. Press *5 on your phone if you are here. I'm going to lock the conference in about 4 minutes. That way we will just deal with everybody's questions here. Okay, you are not here. So I'm not sure exactly. One of the things you can do, I would say, get a lawyer and get the lawyer to pursue your case with the Customs and Border Protection. Let them know that this was an incorrect decision. She's a Canadian citizen. And also, by the way, there is also a waiver available called 212D3 waiver. But that should not be required. I would just contact the Customs and Border Protection through a lawyer and let the lawyer take it up with the CBP. That would be probably the best thing. As to whether she can do an ongoing B2 stay in the United States, and that would come later. First is to get her in here. So you can't really do anything until she can come back to the United States. Okay, so do it through the CBP. That's what I would recommend. Press *5 if you're here. I don't know if I asked that already. Press *5. Okay, you're not here. All right, so get a lawyer, do it through CBP. It does not look like this is an unsurmountable issue. Okay, not insurmountable. This is actually also a frequently asked question. I forgot to mark these questions. What happens if you stay outside the US for more than 8 months as a permanent resident? So as long as you don't hit the 12-month mark, at which point you lose your green card, and then you have to go through all kinds of shenanigans to get it back, if you can get it back. What happens is, if you're outside for, I think, 6 months or more than 6 months, 6 months is the critical mark, you can be questioned very, very closely by the Customs and Border Protection at the airport. But if you are outside for, let's say, 5 months or some days, less than 6 months, you're not questioned very closely. You just walk through. So be careful with that 6-month mark. Now, if you're outside for 8 months, be prepared to answer questions. Why would you go on so long? So carry some evidence. Okay, what was the reason? I was selling my property. Here is the evidence of that. Or somebody in the family was not well. I was helping out. Here is some evidence of that. So those are some of the things that you would need to do. Press star 5 if anyone has a follow-up question on this. Press star 5. Okay, so this part is taken care of. Let's go on to the next question. H-1B lottery, and this is question number 9. H-1B lottery and job change for a master's graduate in the US. Did master's in the US, works for a well-established company A. H-1B registration was picked up from a consultancy company. A may send him to Canada to continue his employment, but he wants to stay in USA. Okay, got that. His EAD expires in Jan 2024. He's also concerned if there can be a second lottery. Okay. So if he chooses to switch his company and file H-1B through consulting, when can he start working for the consultancy? October 1st. If his petition is filed and confirmed to the consultancy before June, but a second lottery occurs, can he apply again? Yes, I think so. I'm not aware of any reason he cannot. Let me think about this. You were picked in the lottery, you got an H-1B approval, then you got picked again. See, the second and third lotteries are very confusing because there are no regulations covering it. If I were him, I would apply. Absolutely. 3, assuming he leaves company A and moves to the consultancy, what are the minimum requirements to start the H-1B transfer process? I would say work a few pay periods. 3 is the recommended time because they normally ask for 3 pay stubs. After October 1st, you can rejoin the old employer. I don't see, not after 3 pay periods after October 1st, which is what it normally would be, you can join them back. I don't see why not. Okay. Star 5 if you have a follow-up question. See, the main thing here is there should be no collusion. Your employer and the consulting company shouldn't have colluded in any manner. Okay, let's see. This is area code from Texas. Texas, go ahead. I can hear you.
Hi. So follow-up question on this one. Do you still need 2 or 3 paychecks if you're filing a new H-1B petition?
If you are filing a new H-1B petition, you do not, of course, because let me give you an example. Let's say you are working for employer X on your OPT or STEM OPT. Your H-1B got selected through employer Y. Do you need pay stubs from Y? Absolutely not. Will you need pay stubs from X? Yes, because you have to show that you are maintaining status. Got it?
Got it. So you said, yeah, got it. Yeah.
Okay. Another thing.
Thank you.
Another thing. Remember that you have 150 days that you can be without job in STEM OPT, and 90 days during the first year of OPT. So if you're still in that period for some reason, even that is considered to be maintaining status. So you should be okay. Got it? Bottom line is maintaining status.
Got it.
Good luck to you, sir.
Okay.
All right. Bye-bye.
Thank you.
You're welcome. This one is Arizona. Arizona. Go ahead, please.
Yes, thank you, sir, for responding to my question here.
Of course.
So my friend here who got his H-1B pick from consultancy firm, there can be a possibility that the consultancy firm, the client can be his current company itself. That in that case it could be a problem.
Yeah, I'm very nervous about those cases, because that sounds too much like collusion. Okay, because here I am working for IBM, and let's say mom and pop consultancy got my H-1B, but they make IBM the end client. I actually had a consultation a few weeks back with somebody, and this guy was a director level job, and I thought that he would be okay. And the company was a Fortune 500 company. There is no collusion. If you are ready to fight that out, that there was no collusion, I think that's perfectly legal. What's wrong with that?
Can you throw a bit more light on collusion? Like what?
So collusion is, we had a conversation, the big company and the small company actually talked and said, you know what, you also file his H1B. And if he gets selected through you, I'll hire him. That's collusion.
Okay.
And if that has occurred, then everybody's in trouble. Okay? I'm assuming you're okay. All right.
Yes, okay, thank you so much.
You're
Yeah.
welcome. Okay. So there's another question from, let's see, what is this state? Minnesota. There are no new questions at this time, Minnesota. Go ahead. New question or follow up on what we are discussing?
Sir, yes, sir. Actually, I think I might have. Is it open forum right now?
No,
or
not
is
yet.
it,
Not yet.
still
No
the
new
questions
questions. No. I'll have the open forum soon, not right now.
Oh, sorry.
So yeah, just stand by. Guys,
Yes,
drop
thank
your
you.
hands if you're asking new questions. Also, let me just close the, I'm going to close our conference.
The conference is now locked.
So we'll just answer the questions of everybody who's here, okay? Let's see, this one is, wait, where is this from? Area code. Okay, let's see. And this is, there are two raised hands. Again, I remind you guys, don't raise your hand. Hang on, I think this one is done already. So that one I've closed down. There's one from Illinois. Okay, I'm assuming it's a follow-up question. Yeah, Illinois, go ahead. Ask your follow-up question.
Hi, Rajiv. This is a new question, actually.
No. Then you need to wait.
Question.
Please wait. I'll get to the new questions soon. There's only a couple of questions left. Next question. Pursuing a second master's degree with day one CPT on F1, what to consider? Currently on F1, STEM OPT ending soon, pursuing a second master's degree with day one CPT. What do you think? Advise on questions concerning the long-term impact. The university is accredited by a regional agency based in Kentucky. They have a residency campus in other states. You only have to go there once a semester. Should this be a concern? You know what? It could be a concern because under the federal regulations, you can only take a certain number of courses offline. You have to take these courses on campus. So that's one thing to look out for. Is the university meeting the requirements of the law in terms of physical presence? Okay. There could be a gap between my OPT end date and CPT start. What would be the best way to work around these gaps? You have 60 days grace period. I would say you could start your CPT from second semester instead of the first semester, if that is a possibility. Otherwise, you have to talk to your DSO what is the best way to cover the gap. I don't know what you could do. You could apply for a B2 status, but then wouldn't that close your service and then you have to reactivate the service? I don't know how that would work. So talk to your DSO. They might have a better idea than I do about this. Many students attend this university for day one CPT. So it was also in the news articles, but the university seems to meet those requirements. Look, in my experience, if a university has come under scrutiny, it is best to avoid that university. I'm an IT developer, but I'm looking for an MBA program. Would this be considered closely related? I think so, if you want to go into management. But the problem is, if you go to MBA in a community college, government may not like that. Okay, but if you go into a reputable school for MBA, and I'm not saying that community colleges are not reputable, what I'm saying is that if it's inherently unbelievable. It's not that the law requires you to further your career, but I think it's such a good idea. If you are going to do this, do it for your career, something that advances your career. And also, if it was ever questioned what your good faith intention was, it can be quite clear. Sure, I want to work, but at the same time, I'm advancing my career as well. Okay. Star 5. If you have a follow-up question on this, press star 5. Next question. TN visa extension and Form I-129 submission without employer's disclosure of financial information. I'm married to a green card holder. Applied for my green card. It might take, EAD and advanced parole might take up to 4 more months. Yes, if you leave USA, your entire 485 would be deemed abandoned, not just advanced parole EAD. Everything is deemed abandoned. You can't travel outside USA, to the best of my knowledge. I have to look at the rules for TN, but I'm pretty sure it's the same rules. In alternative option for my employer to submit Form I-29 for extension of my TN, my employer does not wish to disclose answers to these. You can, if it's a private company, the government may let them slide as long as you can produce your W-2s. Okay. What we do, we've done this in many cases where we just say not disclosed, where it says gross income, taxable income, whatever, net income. We just say not disclosed. And if the government has, I would attach your W-2s showing that you are getting paid. And if the number of employees, of the company is considerable, I would make that point clear in the cover letter that I draft for the TN. So yeah, you should be able to do that. But they should give the current number of employees. I think that's important. But gross and net, they can skip. Okay. Then, Form I-20, yeah, so I just gave you the answer to those questions. Press star 5 if you have a follow-up question on this. Press star 5. Okay. Oh, there is a follow-up. Let's see, where is this from? North Carolina. North Carolina, go ahead, I can hear you.
Thank you, Rajiv ji. A follow-up question. You said, you cannot leave the U.S. What if I leave continental U.S. and go to a place like Hawaii or,
that's
part of U.S.?
Hawaii is okay.
Is that also a problem?
No, Hawaii is okay. I'm not sure what happens in Puerto Rico because that has some weird rules. I have to look it up because I remember.
That's okay. Puerto Rico is fine. I think we are planning a trip to Hawaii.
Hawaii is not a problem.
That's my concern.
Hawaii is not a problem. Are you asking this question genuinely, or are you trying to make us jealous?
No. My parents are listening over the summer. Thanks. Other than that, you said producing W-2 is okay for a small employer if it's a privately held company and they are not planning on sharing those gross income and net income details. And I will have them.
Yeah, another thing I want to point out before I forget, we are doing this for another client of ours. So this client says, I don't want my financial information to be disclosed to anybody. So we told him, what you do is, you give us the financial information in a sealed envelope, okay, which can be only opened by the USCIS. On top of that, just write down to be opened by USCIS only. Consider void if the seal is broken, okay. And what we can do is, we can actually send you the package, you the employer. The employer can then add this information and send the package to the USCIS. We'll prepare the package and send it to you. So that's another way to deal with it. Okay. But go ahead, you were saying something when I interrupted you.
So W-2. No, I was just saying, so W-2 substantiates, I will, of course, add a couple of months of payslip along with it.
Absolutely.
It gives, proof of income for the year, and then I will have a regular TN letter that I created at the time of taking TN.
Absolutely.
But this will be more about extension.
Absolutely. Yes, sir, this should work.
Okay.
All right. Good luck.
Thank you very much.
You're welcome. Okay, I think this is the second last question. Yeah, second last question coming up. So relocating during the prevailing wage determination process on the PERM application. My work location is Seattle. PWD got filed with the Seattle location. I moved to Chicago. Now PWD is approved. Does my company have to reapply? Look, if you're going to go back to Seattle sometime in the future, before or after you get your green card, you can continue your green card in Seattle. Okay. Exactly. I confirm it. What you have read in my blog is still the law. Okay. *5. If you have a follow-up question on this, press *5. Okay. The last question is F1 OPT and H1B process for international students. I'm on F1 now, graduating in May this year. Are there any risks in international travel after my graduation before my EAD? Okay, two members work on the same. Okay, for the travel, if you go to my blog on immigration.com, I have a complete infographic on when you can travel and what is required. It should be around third or fourth page of my blog, which talks about travel during H1B process for students, etc. So go into that blog. Can you travel after your graduation and before your EAD start date? Already have the EAD card with me? The answer is yes. If you have a visa stamp, talk to your DSO, make sure your I-20 is endorsed for travel, and make sure you have proof that you have a job when you come back. You should be able to travel, but like I said, talk with your DSO before you do so. If two family members work for the same team in a company, one in USA and other in India, would there be a challenge in filing for H-1B for that person? Why? Why? Not at all. 0% problem. While I'm on my F1 OPT after graduation, can I also work as a teaching assistant for my university? So first year of OPT, as long as you are working in your own field, you can do as many jobs as you want. But each job should be at least 20 hours each week. Now, this is something I did not know. I just figured this out last week. So I used to think, my opinion was that you could do two jobs, let's say one for 40 hours, one for 10 hours. But it seems like government takes the position, I'm not 100% sure about this, but it seems like government wants to take the position that if you do multiple jobs, none of them can be below 20 hours each week. And they must all be in your own major. That we knew. They can be paid or unpaid. This is your first year of OPT. STEM OPT, the rules are a little different. Okay. All right, very good. I think we are good with this. *5, if there's a follow-up call on this, a follow-up question on this. Okay, so let's get started with new question, guys. Press *5 if you have any question. Press *5 and I will start talking to you in the order that you logged in. Okay, so there is a total of 7 questions. Let's begin with let's see. Oh no, 9. Okay, wow. 10. Let me grab some water, guys. I'm going to put you on hold for just a second, okay? Let me grab some water. Okay. Oh, wow. While I was gone, everybody raised their hand. So now we have 11 questions, 11 people with questions. No problem. First person is New York. So, okay, let me see how I can pick this up. Give me 1 second while I figure this out. Area code. Got it. Okay. New York, area code 917. Go ahead, please. 917.
Hi, Rajiv, you can hear me?
I can hear you just fine.
Thank you. I do have the follow-up question, number 6, related to recommendation letter. Sorry, I just ponder upon what you said. So you mentioned that the content of the letter should state recommenders' credentials, why the candidate is top 10%, etc., etc.
Yeah.
And also you mentioned that the weightage is given more to the people who you do not know personally.
Yeah.
So having said that,
1 second. Can I take you back to the sheer stupidity of that requirement? So here is why this requirement is so stupid. Okay. So let's say that I am someone you know by reputation. You've never met me. You know me by reputation. Great, you know me, but how do I know that you know me? such a
Correct, exactly.
So I think this is logically so dumb. But the idea is, for example, if you have given a lecture in McGill University in Canada, okay, so chances are people in the faculty would know you because they attended the lecture or they know of you. So that's kind of what they're looking for. Make sense?
Okay, so I mean, but my question, my question was like, so there are a lot of sample letters floating around on the internet, right? So how can I ask somebody who's like a reputed professional that I do not know personally to write the letter in a certain format? Like he might just write 2 lines and get done with it.
That's your problem. That's what you've got to figure out how to do it. USCIS's job is to make things difficult for you. So, yeah, see, what we do is this. We have clients who are able to get letters from people who don't know them personally. But let's say you've worked with somebody professionally. Okay. They can always say, I don't know him personally. Our only relationship has been this one project that we did together. Something like that I think should be acceptable. And you know what? The only time I have sued the government was during Trump administration on this issue. On EB1A case, they denied one of my cases, and that was not acceptable. So we sued. And within 2 weeks, they approved my case. So they know when they are being really, really ridiculous, you can actually take them to court over it. Okay.
Okay, yeah. So if the recommender doesn't know me, he or she needs to write it down in the letter that I do not know him or her personally?
Yeah. They can say, look, so I'll give you an example. So let's say you've received a request from a professor in Tamil Nadu for a copy of your paper that you wrote on, I don't know, massive parallel processing using artificial intelligence and deep learning, whatever, right? So you've written this paper and they really want a copy of it. Now you know this guy knows me. I don't know him, right?
Right.
Or if somebody downloads and you know where they're downloading from. So. Okay. Good luck.
Thank you so much.
All right. Good luck. Let's go on to the next one. So in the order, okay, first of all, I have to say done. Yeah, this damn thing is like operating a spaceship. Let's see. Now I want to go to Illinois. Okay, where is Illinois? Oh, here it is. Okay, Illinois is here. Area code 815. Go ahead, please.
Yeah, hi Rajiv. Can you hear me?
I can hear you just fine. Yes, sir. Go ahead.
Hi.
Yeah.
Yeah. So I'm currently on F1 visa and on STEM OPT. My H1B this year was not picked, and it was my last attempt. So I have my STEM OPT validation, like STEM OPT valid till Jan 2024. So more 8 or 9 months.
Okay.
So my question was, if someone is applying for F2 visa, for example, my dependent, after like Jan 2024, that is, let us assume maybe in March or April 2024, does that create a risk, a visa rejection risk for F2 visa holder if like the husband is on day 1 CPT and his F1 visa has been expired?
I think so. I think it definitely is questionable. 1, because you've been gone a long time. 2, CPT is not the favorite child of the government. And 3, your visa has expired. They can always say that we have let him come and apply for a visa again. They normally don't, but they can. So yes, it could be a problematic visa stamping. Okay.
Okay. And I'm also trying to like take cap exempt H1B employer as an option to that. So my question regarding that was, and I know that we can't like jump from cap exempt employer to regular employer on H1B. So what if I've completed 6 years and I have an I-140 approved from a cap exempt employer? And
hang on,
can
let
I
me
switch
stop
after
you.
I-140 is
Let
approved
me
or
stop you for a second. Two things you need to remember. The easy one first. I-140 approval can be from any person, any agency, any company, cap exempt or exempt. Your right to extend your H1B does not depend upon the nature of the I-140 approval. But because you have never gone through the lottery, you will not be able to extend your H1B in the for-profit zone because you never entered that zone. If, on the other hand, you win the lottery and now you have entered the for-profit zone, that non-profit I-140 can be used to keep extending your H1B. I don't know of any reason you cannot.
Okay, but can I extend that H1B for cap employees?
Yeah, I think
after
so.
6 years?
I think so. I don't see why not. Okay. But now let me also come to another point. This is something you need to know. So let's say I've got a cap exempt H1B approval. The law allows you to concurrently work for a cap employer if you want on another H1B. Okay. So let's say I work for the university and the university said, well, you know what, we can cut you down to 20 hours. You can do a full-time job with a for-profit employer, 20, 30, 40, 50 hours, depending on how much you can work. So concurrent H1B is okay as long as you don't quit your quota exempt job.
Oh, okay.
And the quota exempt job doesn't have to be full-time.
Then I can't.
It doesn't have to be full-time.
Okay. But then if I have to do concurrent employment, I don't like I should not work full time for that cap exempt.
You can if you have the capacity to work 2 jobs, sure, by all means. Work full-time 2 jobs, one work part-time 2 jobs, work 1 full-time, 1 part-time. Any permutation combination is acceptable.
Okay.
Good luck.
Okay.
All right.
Yeah, thank you. Thank you so much.
You're welcome. Okay, the next person in line is from area code. It's from Florida. So let me grab Florida. Florida, I can hear you. Go ahead, please.
Okay, so this is about AC-21 portability.
Okay.
So I filed my adjustment of status last August when my date became current. I have an approved I-140 under EB2.
Okay.
I got an RFE in November.
But hang on. Back up just a little bit. You said your I-140 is approved and your 485 is pending more than 180 days, right?
Correct.
Okay. And now you have an RFE.
But I guess that's what my question.
Okay. Go ahead.
No. So I had an RFE in November and I responded it in February. So if I don't know if the 180 days is from the date of my adjustment of status application, or does it not include the RFE response?
No. So let's say the RFE was on the 485 or the I-140?
485.
Okay. So let's take this hypothetical. I filed my I-140 today. It got approved after 100 days. Okay. I had also filed 485 at the same time. Okay. So 100 days later, my I-140 got approved. The law says I have to wait only 80 more days. Okay. What if there's an RFE on the 75th day? Doesn't matter. Even if the RFE, you respond to the RFE, doesn't really matter. It doesn't reset the clock. Your 80 days is your 80 days. Okay. Do you want me to repeat that?
So the RFE.
Yeah, the RFE does not get counted.
Yeah. No, I get that.
Yeah, it doesn't increase your waiting time. No need for that. Okay.
Okay. So the other problem is now my current date which was there in current in August is retrograde, and my
Even that
told me
doesn't matter.
The date has to be current.
No. AC21
so does
doesn't
that affect my job change?
No. AC21 does not require the date to be current. Not at all.
Okay.
All right.
So I can have my AOS pending, and yet I can do that.
Absolutely. Good luck, sir.
Okay. And one last question assisted to this. So meanwhile, I'm traveling to India for medical emergency. My mother-in-law is not well, and so we are visiting there. And I'm traveling on my H1B, my current H1B, which is active. And we are coming back on H1B and H4. Will that be an issue in any way on my I-145 status?
You have your H1B, H4 visa stamp?
No, we will be doing that.
Do not travel on that H1B, H4. I cannot get into all the details why I don't recommend that. I do not recommend that. Okay?
Okay.
Yeah, you can, if there is an emergency like that, try to expedite your advance parole. Don't travel on the H1 without a visa stamping. Okay?
Okay.
Good luck to you, sir.
Thank you.
All right, bye-bye.
Okay.
All right, let's go on to the next question. This one, we have 8 people left now. Other people had raised their hands while we were talking. So I'm going to go to Texas next. Let's see. Texas, area code 832. Here we go. Texas, go ahead, please. I can hear you.
Hi, Rajiv. Firstly, thanks for this initiative. So I'm on my OPT right now, and it was my company tried to file for H1B, and it was my second chance, and it was not picked. My STEM extension expires next year on June, and I was born in Oman. So do you recommend asking my employer to try filing for EB2 or 3?
Absolutely. Absolutely. That's the smartest thing you did. You chose not to be born in India. Good move. So go ahead and file your green card. Absolutely do it. If you want to know a little bit more about this, you can actually Google my name against the Economic Times, Rajivs Khanna, Economic Times, and you will see my comment on this issue there. Applying for a green card while still on a student status.
Okay, so what if the processing time takes longer than my expiration date on the EAD, which is next year?
Hang on. So if that happens, you would have to leave the country or convert to another status like F1 CPT or something like that. And your green card can proceed whether you are inside USA or outside USA. That does not interrupt your green card.
Okay. And one final question: Is it okay to travel once I start the process to India?
Sure.
Or is it advised not to travel?
Why not? See, they usually have not created problem. I always say theoretically they could, but first of all, the green card begins to show up only when the I-140 is filed. Otherwise, it doesn't even show up in the papers. So even if it is filed, I know so many students who got their visa stamping and were able to come back even with the 485 pending. So government is usually not, I have seen at least, I mean, theoretically the possibility is there, but as a practical matter, I have not seen students being bothered. Although I do remember one case in which the 4th year PhD, this lady was denied her student visa, but that was a different case. Entry, I think, should be okay. Of course, there's always a chance you could have a problem, but in the total scheme of things, I think it's not that dangerous. Okay?
Perfect. Thank you so much.
You're welcome. Good luck. Okay, next person on my list is Illinois. Let's see, Illinois, area code 312. Okay. Illinois, I can hear you. Go ahead, please.
Hi, Rajiv. So
Hello.
I'm right now on F1 visa, and I'm from India basically on my OPT. If I get my I-140 approved and then I change my status to H4, will I still be able to get employment authorization based on my I-140 approval, even though my spouse would be on H1B and she doesn't have a I-140 approval?
No, you cannot combine the two. So if you are getting your H4 EAD, it's the H1 holder whose I-140 must have been filed or approved, and there's actually more to it, but let's say I-140 approved. Okay. You can't transfer your benefit to her.
My I-140, which would have been approved.
That doesn't help. That doesn't help getting the EAD.
I mean, no, she's already.
Try again.
No, I mean, it's my benefit for myself, not to her. She's already on H1B. And I'm on H4 with my I-140 approval, which I got when I was on F1. So will that allow me to get work authorization?
No, that's what I just told you. I said that unless the H1 holder's I-140 is approved, there's no benefit of EAD to you.
Okay. All right. Okay.
Good luck.
Thank you.
You're welcome. 848 New Jersey, go ahead.
Hello, Rajivji.
Hello, sir. Go ahead.
Hello.
Yeah, I can hear you. Go ahead, please.
Yeah, Rajiv, I have a question. Yeah, my wife is like H4 and has a valid stamp till 2025, and she is planning to go India to apply for like F1, and she is eligible for a F1. And so the question is like, if F1 like decides, can she come back H4?
Yes, absolutely. Absolutely. Okay. Good luck.
Thank you.
You're welcome. Okay, I just selected area code 314, which is Missouri. Missouri, go ahead, please.
Hey, hello, Rajiv.
Hello, sir. Go ahead. Missouri.
Hey, Raju. First of
Yes?
That was Siri. Sorry, this damn stupid machine. Shut up, Siri. Oh, idiot. Okay. So, back to you, Missouri. I think you got disconnected.
Raju, can you hear me?
Yes, I can hear you. Go ahead.
Great. First of all, thanks for doing this community conference. I really appreciate it, and it helps a lot of people. So, coming back to my question, so I'm on F1 visa, and I am currently doing my executive masters here in university, here in St. Cloud State University of Minnesota. But it's a day one CPT, and I am currently doing my CPT. I'm working for the same company where I used to work in India. It's GE. Okay. And the problem here is, so I already have a PhD in India, and it's from well-known university in India. And I'm now planning to apply for EB1 green card.
Very good.
Okay. So, is it a good time to apply for EB1 while I'm on CPT, or I should wait until I get OPT and apply for green card?
No, I would go ahead and apply for your... Yeah, do it now. Okay.
Okay, so there is no issue even if I'm on CPT?
I don't see any issue. I mean, travel and all becomes
because I heard like...
Yeah, travel and all becomes complicated. You can do one thing you can do. Let's see. So you are currently on CPT. If you go to OPT, you just have to file Form I-765. I am 100% sure, well, not 100%, but quite sure that I-765 doesn't even ask you what is your current status. I mean, sorry, it doesn't ask you if you have ever filed for a green card. So you can take.
So that is for OPT, right?
Yeah.
I mean, when I apply for OPT.
Exactly. So double check that. If you find that there is such a question, come back and talk to me next week. We'll be doing this call on LinkedIn. So 1 week on LinkedIn, 1 week here. In some ways, I like this better because we have better control. We have questions already pointed out. So yeah, you can come back to LinkedIn or just come back here the week after that. Next week, LinkedIn. Okay?
Sure, Raju.
I'm pretty sure there's
Sure,
no question
Raju.
like
And
that.
meanwhile, I'll also forward my
Your CV?
sure.
Yeah. You can send me
And
your
I'll also
yeah. Send me your CV. I'll take a look at it. Help@immigration.com. Okay.
great. I appreciate it, Raju.
Good luck, sir. Okay, let's go to California. Area code 510. Go ahead, please. California.
Hi. So I have two questions.
Go ahead.
So the first one is just a general question. I wanted to know how do I get access to the frequently asked questions and answers?
On our website.
Yeah, and the second question.
Yeah, hang on. If you go to immigration.com, okay, and on the very top gray ribbon, you see the frequently asked questions. They are organized both by topic and date. So you should be able to see them all there. And if you have any problem, just drop me an email to help@immigration.com.
Okay. Awesome. Thanks for answering that. And my last question was, I'm currently on a grace period. My last day working for an employer was March 10th. So I just wanted to ask.
Okay, hold on. Back up a little bit. So USCIS has said that your 60-day grace period begins on the date your pay period ends, not on the date you stop working.
Okay. So that was 1 week after my last day of working.
Yeah. So, okay. So that was very close. So that's when it begins. But sometimes what happens is they'll give you 3-month pay before they let you go. So then your 60 days will begin after the 3rd month. Okay.
Right.
All right. So yeah, go ahead.
So the follow-up is, can a new employer file for my H1 transfer after my grace period ends?
They can, but you'll have to leave USA. Normally, government is not going to approve H1B within USA with status. They'll say, okay, H1B is approved, go get visa stamp. So if you have to get a visa stamp, you could always go to Mexico or Canada. Mexico is very good, actually.
Okay. So before I got your contact, I got a chance to talk to another lawyer as well, and he had a conflicting answer. He mentioned that since my I-797 I-94 validity is until 2025, I would still be able to be lawfully present in the US after my grace period.
Okay. So
never ask you,
never call this lawyer again, ever. Okay. Call anyone. Call your best friend, but don't call this lawyer again. They are dangerous. They are dangerous for 2 reasons. One, remember, as soon as you are let go, the employer is required by law to inform the government to cancel your H1. If the H1 is cancelled, the I-94 is cancelled. Okay, never ever call this lawyer again. Very dangerous man or woman. Next question.
Understood. That was it. Those were all of my questions.
All right. Good luck. Let's go to Tennessee. 615. Tennessee, go ahead, please.
Hi, Rajiv. Just wanted to take a suggestion on my case.
Actually,
I'm waiting on my PERM application approval, which was submitted in August last year. And I will max out my 6 years of H1B on mid of June. That is like less than 2 months now.
ठीक है.
So what are my good options now if it didn't get approved this month, or how much I should wait before taking any other action?
I mean, if you are okay with working from outside USA, just go home for a few months. Once the I-140 is approved or the PERM filed 1 year ago, you can get H1B extension and come back. So just work from India for a while.
any other preferable option if I don't want to leave?
There is no other easy
US or
option.
something? Because if I go India, I know
Yeah.
okay. If I leave US or if I go India, I feel it will be difficult back with the employer or the employment. So
See, the problem is you could try to get back into curricular practical training. You are currently on H1B. So getting
H1B.
back onto F1 is going to take you many months, 7, 8 months, 9 months. And I don't think you can get CPT
So I
until
was never on F1 actually.
Chalo, even if you had to do a change of status first time
came US
H1.
on H1 only.
If you had to do a first time F1,
Okay.
the change of status takes many months and you can't start working until your CPT comes, until your approval comes. So you will have a 6-7 month gap anyway. So I can't think of anything else you can do. Unless you have an exceptional resume and you can think of O1 or something like that, that might work.
Okay. So in worst case, if I because I'm expecting my PERM to be approved this month or next, and maybe if I need a grace, maybe of 1 month or so, and if I plan to go out of US, say Canada for 1 month on my friend's visit or something, so my H1 will get extension when I'm outside US.
Yeah, you can recapture the time you were outside USA.
Because
every day that you are outside USA in those 6 years can be recaptured.
No, I'm talking about the after 6 years. So my max out is June mid anyways.
No,
so
after 6 years, after 6
stay
years,
as much as I can.
No, you don't get any recapture because the 6 years are over. Unless you are outside USA for 1 full year, you don't get anything back. Okay.
Okay, so I have to go for the lottery again, although I have a PERM.
No, you won't have to. Once the I-140 is approved, you don't have to go through the lottery again. But the I-140 has to be approved.
Okay.
All right.
Okay.
Good luck, sir.
Thank you.
All right. Bye-bye. California, area code 310, second last caller.
Hey, hi, Rajiv, sir.
Hello, sir.
Yeah, hi. You're able to hear me?
I can hear you just fine.
You're able to hear me, Rajiv?
I can,
okay.
Yes.
Thank you. Sir, this is regarding my, this is regarding my EAD and AP. So the actual thing is I have 2 EADs and 2 APs. So because it is in 2020, I applied in EB3 and I received the EAD combo card and AP. And again in 2022, I did it for EB2. So the thing is EB3 EAD card is going to expire somewhere in September 2023 this year. And EB2 is going to expire in 2024. So my question is, do I need to renew both the cards when they expire? Or
I have answered this question so many times and always the same answer. And nobody has actually ever written me back. Do me a favor. You go ahead and call the USCIS customer service. Okay. Tell them this is my situation. They will actually bump you up to an adjudications officer because frontline staff can't answer this question. Okay. So if I were to make a guess, knowing what I know about immigration law, I would say, yeah, you just need to keep one. I don't think you need to cover both. But it is best to check with the USCIS adjudications officers. What they'll do is when they bump you up, the adjudication officer will either give you their badge number or their first name. You make a note of the date and the time you called and what they told you. And also email me what they told you to help@immigration.com. I want to know if my guess is correct. And my guess is you don't have to do both. You can just use one. Okay?
So which is the latest one?
It doesn't matter. Whichever one you want to keep. Take your pick.
Okay.
All right.
Okay.
Good luck.
Okay. Got it. Thank you.
You're welcome.
Thank you.
You're very
Thank you,
welcome. Okay, so the last question today is from Minnesota. Okay, Minnesota, go ahead. You're on.
Hello, Rajiv sir. Can you hear me?
Yes, sir, I can. How are you?
Sir, this is regarding this question number 7 regarding my mother's visa overstay.
Yeah, I have already
that I
covered
missed.
it.
This was on
I have already covered it. And what I'm not going to repeat the whole thing. You can listen to the recording. It should be out in a day or two. But what I said was, before you can think of converting her to long-time tourist status extensions, she has to be able to come into the United States. You should get yourself a lawyer, fight it out with the Customs and Border Protection. They should remove any disqualifications against her, because the overstay was completely inadvertent, because she was given that much time by the officers. And so she just followed what they told her, right? So how is that her fault? Right?
Okay, sir. And you are saying that there is a provision for extended stay for visitor visas?
Yeah. So actually, it's there in the Foreign Affairs Manual. I mean, I don't have the citation off the top of my head. It's in 9 Foreign Affairs Manual. If you Google Foreign Affairs Manual, State Department, okay, it'll open up an electronic database of questions, answers, provisions. So go to volume 9. It's called 9 Foreign Affairs Manual Visas. Look under B1, B2 visa, and there's a provision you'll see that you can keep extending your B1, B2. If you can't qualify for derivative like H4, etc., they will let you keep extending your B2. Okay?
Okay.
Yeah. So there is actually a specific provision
okay,
in
sir.
there.
I would actually like...
Ji.
Yes, sir.
Mhm.
I would like to schedule an appointment with you, sir.
Yeah.
And I would like to actually...
Sure.
work with you to... I would like to hire your office to do this for me. So I would like to schedule that.
करवा देते हैं जी. Just go ahead and drop me an email to help@immigration.com. Remind me that we talked about it. I'll get a person from the team involved so that they can start working on your case. Of course, we'll give you a quote first so that if the money seems reasonable, then you can start with us. Okay?
Okay, sir. Help@immigration.com?
That is correct. Okay?
Yes, sir. Thank you very much, sir. Very much appreciate all of your community service.
Always a pleasure. Good luck. Ladies and gentlemen, I think we are done for the day today. As always, it's a delight and a privilege to be with you. I'll see you again next week on LinkedIn Audio. Okay? Good luck, everyone. Take care. Bye-bye.